Your moderator today. My partner Cliff Rosenthal will be joining us. Cliff is probably one of the smartest lawyers that I know when it comes to understanding H-1B strategies.
Hi, everybody.
Welcome, Cliff, and certainly a pleasure to have you join us today. This program will run for approximately 1 hour today. We may have some time for questions, but if you do, please keep them very, very brief because we have a lot of material to cover today. So briefly, for those of you who are not familiar with the Wolfsdorf Immigration Law Group, we are now a 7-office firm. The reason we have grown so much and so successfully is because we have focused on innovation and technology, and we have created Rapid, which is the most advanced cloud-based immigration management system. So in a nutshell, we will be covering all aspects of the H-1B new proposed rules. We will focus again on strategies relating to prevailing wage. We will focus on the meaning of specialty occupation in the DHS new rules, and we will also focus on the off-site location updates. Now, I do have to mention that this is not legal advice. If you need legal advice, you need to contact one of our attorneys. The general email is visalaw@Wolfsdorf or 1-800-VISA-LAW if you need to reach us. We would be delighted to be able to help you, but this does not constitute legal advice. This is for discussion purposes only. So again, a little bit about our firm. We are top rated. There are only 2 firms in Chambers, USA that have band 1 rating, and we are proud to be one of them. So we are truly thrilled to be able to serve you. These are all various titles and blah, blah, blah. Enough of that. And there we have it. My partner, Cliff Rosenthal, is the founding partner of this firm. Together, we started many, many years ago. Pardon me. And there's Cliff's contact, crosenthal@wolfsdorf.com. crosenthal@wolfsdorf.com. If you get confused, I think Cliff@Wolfsdorf also works. So there we are. That's Bernie. The truth is there's a little bit of an old picture. Have some more, a little bit more gray hair than that. But yep, that's me, certified specialist, over 25 years. And there's my contact information, which is my name, Bernard@Wolfsdorf.com. If you have questions, if you have problems, if you have needs, please email me at Bernard@Wolfsdorf.com. Please give me a little bit of time. We often get hundreds of emails after presenting these particular webinars. So without further ado, I've been stalling to give people time to join us. And again, the topics will be, number 1, the Department of Labor's new prevailing wage level for the H-1B, for the E-3. The E-3 is the Australian equivalent, so it only applies to Australians, and to PERM applications. PERM, as you may well know, is the process whereby individuals can apply for employment-based 2nd and 3rd preference petitions. It is the way that most employment-based cases result in a green card. So we would say this is not just important, this is absolutely critical. This is the heart and the liver and the brain of business immigration law. So absolutely critical, the prevailing wage issues. We will also get Cliff's deep insight into strategies relating to prevailing wage issues. Now, there are 2 new rules. The second new rule, of course, is the DHS Interim Final Rule. What does Interim Final Rule mean? Well, yeah, they go and collect all these comments, and then normally they're supposed to read them and change, but they're going to make the rule effective immediately upon the close date of submission of comments. I would encourage you all to submit comments because this is the only opportunity you're going to have to comment on what's going on here. So we will then go into the proposed revision to the definition of specialty occupation. Specialty occupation, of course, is the critical and essential criteria that you have to meet in order to qualify for the H-1B and for the E3 as well. The fourth topic, we've all seen a considerable amount of enforcement, compliance, worksite inspections. This is a highly regulated area. We are anticipating a substantial increase in enforcement, compliance, and worksite inspections. So for all of you, you know, you've got to play by the book. You've got to play by the rules. People who want to play by their own rules may well end up running into an uncomfortable situation. And then again, at the end of the day, there are hundreds of thousands of H-1B workers stuck because of the waiting line. And there are issues about how we will be able to retain these critical H-1B workers. So we will outline some corporate strategies. If there is a solution, there's a problem. Let's try that another way around. If there's a problem, there's a solution. And we have to find the best possible solution, because this is a quite chronic situation. So as I mentioned again, two rules: the Department of Labor rule, which is already effective October 8th, and then the Homeland Security DHS rule, USCIS rule. So as you all know, when you file an H, you have to get approval for both. They're two separate rules. The DOL Prevailing Wage Rule is already effective. The DHS rule will become effective in December. They focus again on specialty occupation. What is a specialty occupation? They focus on employer-employee relationship. There has to be a genuine employer-employee relationship. That means self-employment is not permitted. That means the employer must be able to hire or fire the employee, and the employee cannot control the employer. So it has to be a legitimate relationship. Then we have the issue of third-party work sites. This is primarily impacting contractors, but gosh, in today's environment, we're working from home. Is that a work site? Yes, it is. And then we're talking about enforcement provisions, which is, you know, what are the consequences? So I'm just framing it. Cliff is going to be filling us in. And let's talk briefly about the DOL Interim Final Rule. Cliff, please give us the background. Explain in perhaps a little bit more detail about what is an LCA, what is a PERM? Very briefly.
Right. Thanks, Bernie, for that introduction. I was so enjoying your introduction. I almost forgot I was a panelist.
Oh, we're relying on you, Cliff. So please don't fall asleep there, and don't get tired of my jokes.
After 20 years, I'm kind of used to them.
Yep.
So the new interim rule relating to the wages only relates to those applications that require a wage, and not all applications do require a wage. So in the temporary visa, in the non-immigrant visa arena, it's really what we call your H-1B, which is your standard professional visas, the H-1B1, which is a similar visa, but that's by treaty, that's only for Singapore and Chilean citizens. And then you have your E3, which is essentially an H-1B for Australians. So if you're dealing with any other visa, if you're dealing with any other temporary visas, O1s, J1s, F1s, F1 OPT, then this rule doesn't apply to you. It's only really to those that require labor condition application, which are the visas I just mentioned. And in these visas, really what the employer has to do, they have to attest that they will pay the higher of what's called the prevailing wage or the actual wage. And the prevailing wage is what has been changed in this new rule. The prevailing wage is a wage that is determined either by the Department of Labor or an appropriate wage source. And we're going to see in a little bit of detail what that means in a minute. So it has to be something that's a DOL wage, Department of Labor wage, or something that they accept. And that's going to be called your prevailing wage. The actual wage is what your particular company, what the petitioner's particular company pays to similarly situated workers, workers of the same with the same skills, with the same level of experience, more or less. And then you have to pay what's the higher of those two. So that's really where this comes in. So the prevailing wage has to the prevailing wage is really is what this regulation is going to look at, which is in turn it's going to be we're going to see in a minute that it's going to be the Department of Labor source, which is really the particular type of wage that is going to be attacked.
Cliff, let me jump in here where, basically the LCA, a lot of people think, oh, this is a simple thing. I check a couple blocks, they all get approved. It's more of an attestation than an application. I mean, they call it an application. They used to call it an attestation. You certify that you have complied with all of these things. You click, 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 you submit it to Department of Labor, a week later you get an approval. But I think a lot of people need to understand this is not just click, click anymore. Because once you have that DOL and once the information is in there, it's going to be subject to incredible scrutiny. And you better know what the term prevailing wage means. You better know what the term actual wage means. And you better make sure that you provide adequate and compliant notice to all other employees. So we have these requirements. I think a lot of people have been a little bit too lax about the LCA. Employers, lawyers put stuff together. So you need to know what these things are all about. Cliff,
yeah,
what about
I think, yeah, just before, I just want to just reiterate your point, just with the point that we're going to make a little bit later. So many reasons why people think it's just a box to tick is simply because the audits have been very low, the level of audits. And what we're going to see when we get towards the end of the presentation is that, audits are going to be up. So it's very critical that you do understand, because even end user names are going to, end user clients, they're going to be listed on the LCA, and we better make sure that the wages are pristine and they are correct, because we do expect higher levels of enforcement, as we'll say later.
I'm thinking of a DOL audit that I handled fairly recently, and it took like a year or two, and it was quite excruciating. It's one of those things, once you get pulled over, you wish you weren't speeding. So let's move on right now. What was the prior system? Okay. And how did the prior system work, Cliff?
Okay, so, in the prior system, the truth of the matter is the system really didn't change so much, but some angles have been shifted, have been pivoted. And the way the prior rule worked was as follows, is that there were three main ways you could create a prevailing wage, or what the prevailing wage would be. And the first one was be a collective bargaining agreement, a union agreement, CBA. So if you have a CBA, then no matter what, that's going to be the prevailing wage, because that's a wage that has been negotiated between the employer and the employee, the organization, and the union, and that's going to be considered their agreement, and Department of Labor will accept that agreement, and that will be the prevailing wage. So
wait, Cliff, stop here. Wait a second. So if my firm unionized, our firm unionized, and we paid $10 an hour, which hopefully is not below minimum wage, and that is the actual collective bargaining agreement, then the prevailing wage for that particular worker in that category is $10 an hour, regardless of whether the Labor Department says it's $100 an hour, right?
So that is correct. Assuming it doesn't trump any, or it's not below any of the labor laws.
What's your adjectives there, Cliff? But yeah, sorry, bad joke. You just said it might trump something else. With no politics today.
Trump on the brain.
We're sticking to the facts here. So we were just explaining again, pardon my silly humor, and I just noticed Cliff's been copying my accent, but the collective bargaining agreement, and I'm harping on this because it's actually a point that I really want to make. I'm not joking, I'm serious. Cliff, sorry, I interrupted you.
Yeah, so essentially the collective bargaining agreement is going to be the wage, and for better or for worse, if it's high or low, that's what it's going to be. And that's that's the first point of call when looking at a prevailing wage. The second one is what I would say just about 95% of everybody doing H-1Bs were using, and that was the Department of Labor's own survey, DOL's own Bureau of labor statistics, BLS, occupation employment statistics, OES survey. And essentially why everybody was using this was it was very easy. There's a website, you type in an area, a location, because all wages are localized. You type in a location, you type in a job occupation, and voila, you get 4 levels of
Does that give you safe
wage.
harbor by any way, Cliff? Is one better than the other in terms of protection? Is the BLS, if the employer relies on the Labor Department, is that acceptable? And my second comment is, wasn't that a median wage anyway, and a little bit too high anyway in many instances? I mean, we already had a problem.
So it's in order, in answering your first question, is it a safe harbor? So it's a safe harbor depending on how you file it. If you file it with a wage request of the Department of Labor, and they give a labor determination, then that will always be a safe harbor for you. The problem with that is that can take 4 to 5 months plus to get. So in practice, most people didn't use the safe harbor, the prevailing wage for H-1B purposes. Some did, but most do not. So when you rely on their surveys directly without requesting a wage, then you don't have a safe harbor. And then, if you're audited, they'll check that you picked the correct wage, the correct occupation, the correct locale. So there is some risk, but generally it's really quite straightforward. In most cases, the occupation is straightforward, and the working out the wage is relatively, and I say relatively, objective. But there's some risk.
So let's move now to the employer surveys. We used to use these all the time in my youth. Watson Wyatt, employer group, a whole bunch of people, Radson, whatever, provide. Some of these are very, very expensive, and very often only the big companies have access to these employer provided surveys. But it may be that in today's world, we're going to have to pivot to number 1 and number 3, because it looks like number 2 has turned from ridiculous to absurd.
Right.
But what do you think?
Yeah, so definitely, we're gonna discuss a few examples. Why number 2 has become on the absurd side, and we're going to see that this is really, this is the point in the new rule. This is the only wage survey that has been attacked. So
there we have it on the slide.
Yes, there we go. So you can see that the level 1 used to be the 17th percentile. So really what they did was they took their existing wage survey, and then they just made the percentiles higher. So you can see that this level 1, level 2, level 3, level 4, and that's supposed to really be the level of the job. So level 1 is supposed to be an entry level, level 2 a little bit higher, level 3 even a little bit higher, and level 4 is really supposed to be the top. So in terms of the wage, what they did was level 1 used to be 17%, and now it's up to 45%. So the 45% of the wage survey is going to be for level 1, which is very, very high from what's it's almost half. Half the top wage is reserved for level 1 almost. And then you can see how it goes: 62, 78. 95, etc. So these are really the application, how they did it. They didn't change the wage. So the wage survey is the same, but the levels have gone up, and it's gone up quite significantly.
So it's just artificial. I mean, they're not even trying to pretend that this is the real wage that people pay. They're just coming up with some absurd new numbers as a device to make it difficult to apply for H1, and also to drive wages up. And I kept saying I'm not going to be political, but Cliff, I just saw that unemployment in the tech sector has gone from 3% to 3.5%. And I know I'm not allowed to talk politics, but this is nonsense. But anyway, let's see it in real life.
We're gonna see it. Yeah, we're gonna see it in real life in a minute. I just before we see it in real life, and we can see exactly what Bernie's saying, is that it has really zero to do with what wages are in real life on the ground. I just wanted to mention a couple of things, just who it applies to. It applies to, essentially it applies already. So if you have a labor condition application in LCA, anything filed after October 8th, the new wages are already going to apply, number one. Number two is if you've got a green card application and you've got a wage required for green card application. So wages for green cards are also very important because you're supposed to advertise for the position, make sure no U.S. workers are qualified. If you advertise for the position and you advertise with a very low wage, then U.S. workers aren't going to qualify. So you have to make sure that, so immigration wants to make, and the Department of Labor want to make sure that the wage is correct, what they feel is appropriate for the position. So that applies.
Let me translate that into English. So if you advertise a job, janitor wanted $8 an hour, presumably there's no or very few applicants for that job. But if you advertise senior janitor wanted $200,000 salary, maybe I'd apply for that job, right?
I certainly would.
Okay, got it. Thank you.
You're right. So when it comes to prevailing wage requests, that refers to any case adjudicated after October 8th. So if you filed it 4 or 5 months ago, then you're going to have the new wage applied to you, even though you applied 4 or 5 months ago.
Oh, shucks. I didn't know that. What does that mean for the pipeline cases? Okay.
So, yep. So for pipeline cases, we're going to get very high wages. We may have to retool and look at the alternative wages, which we're still going to get to.
So the cases we already got may need further attention, even though they're already in the process, right?
Exactly. Unfortunately, that's just a hazard of the profession. You know,
there's no grandfathering,
no grandfathering, you know, no notice, no nothing.
And I don't want to laugh about this, but you know, some poor people have been waiting in line for decades, and now they're subject to these new rules. I mean, that's just not fair. I mean, the only, you know, and I'm talking about the backlog countries, primarily India and China. This just doesn't sound right to me. Why is it that they get worked over when, you know, they're so critical at this point?
Right. That applies especially in the H-1B arena, because even though it doesn't apply if your H-1B is currently approved, you don't have to start paying somebody, employer doesn't have to start paying an employee the wage now, or if the LCA is already approved, you don't have to, you know, you don't have to file a new one. But where it's going to be very interesting and maybe heartbreaking in certain cases is extensions. And Bernie, that's your point well made, is that certain employees have had you know, certain wages for 10 years, and suddenly, you know, their wages didn't go up 50%, 60%, as we'll see in a minute, that some of the wages will go in terms of this this new rule.
Cliff, you know, a lot of the new regulations in the last few years have been enjoined by the courts, and everybody's like, oh, this horrible stuff comes down, and then, you know, AILA, my association that I and others, NAM, National Association of Manufacturers, Industry, Chambers of Commerce, whatever, numerous entities are then suing the government, saying this is wrong, this is not based on statute, you haven't done it correct, violation of the APA, and they've had some considerable success. So, Cliff, can you put on your fortune teller hat quickly and tell me, do you think the DOL reg has got a chance of being enjoined, and the DHS reg may be enjoined? You know, what if there's a change? What if Biden wins the election, or what if Bernie gets elected? No, I'm not running. But what if we have a new president and they change, or Congress changes it? Maybe the Congress changes it.
Well,
what does your crystal ball say? Is this wage thing going to happen? Well, it's already happened, but do you think that there's a chance that maybe the courts will enjoin one or other of these?
Well, my crystal ball definitely says that Bernie would be good for president, especially for immigration. And I mean Bernie Wolfstorff.
Yeah, thank you.
Jokes aside, the truth of the matter is we've seen a lot of litigation on various rules during the Trump administration, and virtually all of them were enjoined, which means they were prohibited from being implemented for a certain amount of time. Usually they were temporary. Many of them were temporary, but in the end, it seems most of them were were accepted, some not, but most of them. So I think there's a very high chance that it will be temporarily enjoined, which means prohibited from implemented, which could last for some time. And then if if the administration changes, then certainly, these rules are up for overturning. And it's hard to say what will happen and what will not happen. I mean, we've seen a very strange, again, not to talk about politics too much, but we've seen a strange change, with Republicans have, certainly positioned themselves as the party of the worker, and we have to see, how, the Democrats, who have traditionally been the party of the worker, are going to act, either to counter that or to prove that they're the party of the worker. So I certainly think that litigation.
By party of the worker, you mean protect American?
Protect American worker, yes.
Yeah. Okay. I'm going to differ from you. I don't think there's going to be too many judges saying that they can't raise the prevailing wage. I think we're going to have problem on the DOL wage, and I think we may have some success on the DHS wage, but I'm totally making this up based on my own thing. So Cliff, let's move on to the question of application. How does this apply? Can you summarize that, and then we can show some examples?
Yeah, I just one normal typical example I would say is of software developers and computer managers. We see a lot of them. I just based on the previous slide where we spoke about how the percentile has increased. So I just want to give you a sense. When we say something's in the 4th level and the 95% percentile, generally for most positions, certainly software developers and computer managers, a bachelor's degree plus 5 years of experience, that requirement, or master's plus 4 is going to get you into the 95 percentile. So when you think of that level 4 is the 95, you're not saying a bachelor's plus 20 years of experience. You're not looking at a massive amount of experience, but you're really looking at kind of a normal, a normal mid-level type of experience.
This is not a heavyweight, Cliff. The bottom line is this person is somebody who's not an entry-level person, but somebody who's quite valuable. But let's put it this way: this person's not a big shot. In my opinion, this is a mid-level critical worker, and your comment here is that these wages are already probably higher than what most US workers would receive. So they're making it extremely expensive to hire a foreign national. And again, this is assuming you're using the DOL wage, because we've spoken about these alternatives of using a union wage. We've spoken about using a reliable survey. And one thing I'm going to tell you about surveys, you can't just use any survey. The rules on survey are very explicit. So if you're planning to do a survey, that has to be done 100% correct, or it's quite frankly worthless. So that's why I use the word safe harbor. Not that we get safe harbors from these things, but safe harbor is the only thing that can't be attacked by the Labor Department. If you use a crummy survey or a defective survey, you're skating on very thin ice. So Cliff, let's have an example of this, and please everybody hold your breath, because when I look at this, I kind of might fall off my chair.
Okay, so if you're gonna fall off your chair now, don't wait for the next slide, because then you might be in real trouble. You'll be worse off.
We're trying to make some humor, guys, but honestly, there is no humor. This is terrifying and tragic. Actually, is the word that I would use. It's tragic because my view is the impact on the economy, the impact on our country, and the impact on the poor workers, and the impact on the company. They're talking hundreds of billions in losses. So, we're trying to be a little bit light because this is scary stuff, and it's maybe we're laughing more in anxiety. But Cliff, explain
right. So yeah, if you look at the slide, you'll see a classical Department of Labor survey, and these are the current surveys. You'll see the levels on the left side. You'll see
that's more than you earn, Cliff. Level 4. I mean, wow.
I'm looking for your janitor position, Bernie.
Yeah, sure.
200K. Yeah,
it's insane.
Right. So and just remember, when you see that level 4, software developer, it's very mid-level. bachelor's plus 5, the minimum wage according to Department of Labor now is 202K, and that's up 42% from what it was before this rule.
My
So
gosh.
wages didn't go up 42%
In one day.
well, yeah, since July, so in 3 months, correct. So
Yeah, well, on October 8th, these new numbers suddenly appeared as the new number, and it's totally made up stuff. I mean, they just put a formula on it. It's not the reality. This is not based on averages. This is just totally made up numbers. And then for medical scientists, like we really don't care about, health and medical science, but that's almost silly. So they made an exception for epidemiologists. So COVID researchers don't have to pay these stupid numbers. Pardon me calling them stupid numbers. I can't think of another word. Fake numbers. That's what they are.
right.
Fake numbers.
So even to get into that level 1 wage for the software developer, the minimum requirement is a bachelor's plus 2, and that's going to get anything more than that. If you ask for a master's degree, bachelor's plus 3, you're already going to get into level 2. And then, as medical scientists, many postdoctoral scholars that come out of their PhD, they're probably earning half or maybe a little more than half of the 93,000 minimum salary. So these wages are very high.
I mean, the reality is that the researchers are not earning this kind of money. They don't have this kind of grant money. They are moving science forward. So we don't basically allow people to do medical science research if we have to rely on these. And we're going to have to look at the other alternative options if we're going to keep these people or bring these people. But I can think of nothing more important. Well, maybe software developers are more important. I'm not sure, because quite frankly, they're both almost the same right now. Medicine and science and software development are all fusing. But so what you're telling me, Cliff, is that a software developer level 4 is now over 202,000 a year, and is that including overtime? Is that including overtime? Does that include bonuses? What does that include, Cliff?
Well, it certainly would include. It would include any bonuses that was actually promised. So guaranteed bonus would be permissible, but an optional bonus based on whether the company did well or based on performance would not.
Which is the only kind you ever see, quite frankly, that I ever see. That bonus I promised you, Cliff, it's not guaranteed. It's optional. It's based on your rating today, and that's how employers work. I mean, you've got to prove yourself. You can't just do this. I mean, how are companies going to work on this? But I am going to move on to the next slide and ask you to explain. This is now, right, we moved up to our NorCal office.
Exactly. So the previous was just for Los Angeles. Now the wages for San Francisco, for the San Francisco Bay Area is very interesting, because for some reason, none of the wages have been, there's not enough data for the wages apparently based on these percentiles. So what that means is that the minimum wage, which is considered for for any application for that matter, of 208,000 will be the minimum according to the Department of Labor survey. So if you have a software developer who's level 1, who's just out of school, the minimum wage from this is going to be 208K minimum in San Francisco.
This is madness, Jeff. This isn't stupid. It's not fake. It's complete lunacy.
Right. I mean, yeah, I know salaries are higher in the Bay Area, but it seems on the high side, definitely. So
it's crippling. Well, what about for startups and people with limited funding, and they giving stock options instead? And your number 3
I think
employees.
That's a great point. I just don't think that the immigration laws kept in touch with what's going on in the economy, especially when it comes to tech workers. It was developed in a time before tech workers and before startups and before stock options and all these kind of. But
this is
things.
the future of America. This is our only hope. This is striking at the heart of America. There's one area, thank the good Lord, that we still have some strength in, which is our technology. And what this seems to be doing is shooting yourself in the foot. No, this is cutting off your own feet. This is cutting off your head and your feet. I can't get it. But let's continue to explain rather than sit in a state of shock. And let's pray that courts see the insanity attached to this, because I actually am a little bit worried about my country. I know I have a funny accent, and Cliff keeps copying me, but I'm an American and Cliff is an American, and you know, this is shocking to me. So Cliff, let's talk about my favorite word. It's called solutions. It's called strategies. And, you know, Cliff, one of the things I like about you is you're creative, but you're conservative, because we cannot break the law. That's not allowed. It's not going to happen. You can't drive over the speed limit. That's not an option for anybody. We all have to play by the book. So, Cliff, looking at the book and being creative, what do you see?
Okay, I mean, the first one is I put a smiley face there with unionize, with union. I mean, certainly if you're
Not
union,
going to happen, Cliff.
it's probably not going to happen. I think many employers might be more terrified of unions than of prevailing wages.
But wait a second, there's different types of unions, right? I mean, well, there's only one type of union. I mean, you've got like some unions have a reputation for being really hardcore, but I know you deal with unions every day, Cliff. And some of the unions I know you deal with are quite reasonable. In
fact, most of them are quite reasonable. Most of them.
That's good to hear.
You know,
most of them I always think of the image people get. You know, I don't want to mention a union specifically, but some unions have a reputation for being very hardcore, and others want to work with employers because they realize that this is in everybody's benefit at the end of the day. A decent, fair union protects the workers and also can help the employer. In this instance, the question is whether the employer will see that as an option. I don't know.
Right. So the real solution is and the real strategy.
Stop. I want to butt in again. Sorry, I'm so rude. You can unionize some jobs. So in our firm, our law firm, we have like about 130, 140 people. Technically, we could just unionize the
lawyers, Bernie.
Not the lawyers, the administrative assistants. The lawyer's not going to happen. That's your job. The administrative assistants or the paralegals. What if we just created, there would be a paralegal union, and that would be the prevailing wage, right?
Yeah, I mean, it's very possible, especially in the big tech area. It could be worthwhile to do that.
Great, thank you. Sorry, I keep interrupting.
No problem. So I think that for most, the main strategy is going to be to get what's called an alternative wage survey. So as we saw at the beginning, the CBA is the one, then there's the DOL wage, which is being under attack. And the third one is hasn't been used too frequently in the past, and that's an employer to provide a wage survey of its own. And the different types of it. It could be one that's already in existence. It could be one that's customized specifically for this, for this application even. You just have to look, and depending on the availability, as Bernie mentioned, there's so many requirements. I've listed some of the requirements below. These aren't even all the requirements, but these are the main requirements. But you almost have to be a statistician in order to work out if the wage is really going to be accepted or not. Yeah. But there are certain ones that have been accepted, and we use those regularly, and that is definitely a very good alternative. So if they're in existence, then we definitely, we have already been using it even since the last wages were published in July. Before this rule, we've already started using many wages, Radford, certain other ones. If there's no wage, then certain occupations don't have a wage, or they have a wage in certain occupations, but not in the particular area of employment. It has to be in the what's called the MSA, what's in called the normal commuting distance.
Statistic computing. I think it's about 75 miles normally.
Exactly. So you've got, it has to be localized data, and a lot of wages are not, or surveys are not localized. They got national or they got regional, and they're not localized, which is
But
the
there may
main.
be a cottage industry with this DOL rule. If I was in the survey business, I would start developing surveys specifically. So
I
those
think
of you who are in
I
the
think
survey
that's going to
business,
happen. Yeah, I think it's going
that's
to
the
happen.
American capitalism working here, is that there's a new cottage industry of doing surveys and providing what I'm going to call honest and real surveys, as opposed to these kind of fake news things that just are made up to, in my
Right.
opinion, make it more difficult for employers. And it's being sold under the hat of this is to benefit US workers, but if you push wages through the ceiling and you bankrupt the company, then how does that benefit anybody? But I will try and keep quiet for a while.
Yeah, I mean, at the end of the day, I think that's a very good point. Is that the alternate survey industry, so to speak, has not really been examined, evaluated, and I mean, for so long, the DOL survey has just been very easy. As I said, you pretty much you put an occupation and an area into a database, and you got a wage. And for the most, sometimes they were high, but they were generally reasonable, or if not reasonable, even livable. They weren't so far beyond. But now I think for sure that this industry is going to develop, and we're going to see more and more wages, and more companies investing it. And they just, if they're not available, they can be expensive. These are just the kind of things that we're seeing.
We're focusing on this because it's such a big issue and it's such an important issue, and we want to keep emphasizing it. The purpose of today's webinar is to explain it. We want you to share it with your friends. We want it to go viral. We want to start a movement here to get this right and to actually fix this. We're not just here to explain this to you. I think for the sake of our nation, for the sake of the workers, for the sake of the companies, I think this needs to be fixed, because this is just a horrible thing that's being done to immigrants and potential immigrants in precisely the area that is needed at this point. And even doing these alternate surveys, Cliff, I remember when I sent out questionnaires to everybody to find out what their salaries was, nobody wanted to share with me. Even my friends didn't want to share with me and let me know what they were paying their workers. So it's not so easy to collect.
Well, while you're making that plug, and why we have so many people on the line, the real reason why the DOL surveys are so skewed to begin with, and even before the new rule, is simply because companies would not would not respond to DOL surveys. That's so it's very important to respond to those surveys, because
please
many companies just wouldn't do it, and when you have a small sample, it can be skewed, and that's why they actually fluctuate each year so much, even though it doesn't seem to be in relation to the cost of living.
But I think your point is, because I think we have many employers on the line right now, is employers need to start sharing their data with, unfortunately, even their competition in their area, because it's in everybody's best interest. But of course, I'll stop interfering in how people run their company, other than to just explain some possible solutions, because there are strategies. As I said, every problem has a solution, and what's the best solution? And that's why we're focusing on this. We understand unionization may not work. Alternate wage surveys, published wage surveys may well. This slide is probably the most valuable slide in the whole presentation, because it's providing some answers, some solutions. But we need to move away from the Department of Labor. We've been focused on the Department of Labor. We mentioned at the beginning that there actually are 2 regulations. There's another one coming down. My view is actually, it's supposed to be finalized in December, but my view is they've actually been trying to enforce this now written proposal for years. That it's not new to me. There's some new stuff in there, but when we challenge them in court, we actually tended to win. We don't file a lot of lawsuits, but we filed some, and we won. We always won because the judges agreed with us. What we presented was real, and then very often the government would just settle, approve the case, and we move on with our lives. But now they're changing the rule book, and we're going to have this new integrity. I really can't use the word integrity. Call it whatever you want, but it's not about integrity at this point. Some aspects involve integrity, of course, but it's really about restrictions in the new H-1B. And this becomes effective on December 7, unless one of my prayers is answered and it's enjoined. So I think there's some chance this thing may be enjoined, but the truth is they're already applying this in many instances. And, the courts are changing, and the president has been winning in some of his court cases, depending on which judges they get. And there's more conservative judges, etc. So we don't know what's going to happen on this one. But again, just to briefly run through your captions, this is allegedly to strengthen. It applies only to the H-1B program. Wait a second, Cliff. So this doesn't apply to the E3 or the H-1B?
Yeah, it's H-1B, H-1B, E3 applies to all the
and H-1B1, which is the Chilean, Singaporean, and
all the H-1B versions.
all the H-1Bs, or as everybody always writes, HB1. It's not HB1, it's H-1B, and then there's H-1B1, and then there's also the DOD versions. And anyway, if it starts with an H-1, it applies. This rule will apply to them, and that will include the Australian E3. And here's the scary part. This is what you need to focus on, is they narrow the definition of specialty occupation. The rules on specialty were actually fairly generous, fairly broad. And, if you package the case well, you could argue that this person met the specialty requirement, even if they didn't. The easy way to explain an H is the old-fashioned professions: doctor, lawyer, engineer, accountant, dentist. What is the degree that even Cliff has? A law degree. Great. What is the degree that a dentist has? A dental degree. Well, what if Cliff had a dental degree and not a law degree? Well, they wouldn't approve his H, because clearly that's wrong. So the degree had to fit the occupation. That's what they're talking about. We'll go into the weeds a little bit more. And then the second thing is they're saying real offer to real employees. What this is that in many instances, employers would make job offers on a prospective basis. So there wasn't really a job because there wasn't really work to do. It's what we'd call a spec employer. And then they would get the foreign national in, and then they would run out and try and find people who needed the services, which, that's how commerce really works, but they turning it into real for real. The truth is that's unreal for unreal, but they calling it real because industry doesn't work that way. Why are we doing this webinar? Well, if you want the real truth, we're doing it to pick up new clients. We don't know who they are. We're hoping that you'll go and tell your boss or your employer, hey, we want to work with WR, and why is that wrong? What are we doing wrong? That's how the world works, but they're trying to change it into an unreal framework that you have to have lined up 3 years of contracts before you can even get a 3-year approval. That's kind of weird stuff. And then they're going to enhance the enforcement. But rather than just talk about what it is, let's go to the guru, my guru, Cliff.
Okay.
Cliff, tell us a little bit more. I've covered some of this, but just
very, very, very quickly. In terms of the background, specialty occupation is an H1 position, and that's independent of what the person has in terms of their degree. But the position must require a bachelor's degree or higher in a specific field. We call that a specialty bachelor's degree. So a position that requires a specialty bachelor's. So for instance, lawyer, doctor, it's impossible to become a lawyer or doctor without a degree in that field, in that specific field. If you're a taxi driver, you may have a PhD, but it doesn't. The position doesn't require a PhD. You don't need a PhD to be a taxi driver. And those are the two extremes. And then you've got in the middle, you've got all those other, positions that most of the time do, but sometime maybe they don't, and that you've got your software engineers. It's possible to have most have a degree, but some don't. You can learn software engineering. And it's very common with marketing and business positions and certain engineering positions.
And the
So
reality, Cliff, is when they created the H-1B visa, we didn't have software engineers because it preceded the software. So the problem is that even though this is the critical engineer, critical occupation, the H-1B, quite frankly, was not really designed, and it probably, if Congress got its act together, should create a new and separate category in the computer arena, because the computer arena doesn't really fit this traditional idea of what is a professional, doctor, lawyer, engineer, accountant. But in my youth, so I'd like you to just talk about that evolution, and then also talk a little bit about the business occupations where we seem to have quite a bit of problem.
I mean, certainly, yeah, the H-1B hasn't evolved with the times. It's over 30 years now with very minor changes. So yeah, it definitely needs to, it needs maybe even a special category for this would be useful for these software tech positions, because they just weren't thought of.
I want to start advocating for that, because that's really what needs to be done. I'm scared they're not going to reverse these DOL wages, and surveys and unionization. Yeah, sure, they're alternatives, but they're not good alternatives. They don't fit all the cases. And quite frankly, we need a new one. So Cliff, explain the word always to me. Always. I always interrupt you. Does that mean I interrupt you every time, or just sometimes? Explain what that means here.
So that, I mean, that's the key. I mean, what happened is in this new specialty occupation definition, in the old definition, it used to say it was normal for the position to require specialty bachelors, and the courts have found that what normal doesn't mean all the time. It doesn't mean every single time. It means most of the time, or what's common, what's typical. And what's changed now is they removed the word normal from the definition. So now we're not exactly sure how it's going to be implemented.
Well, I'm going to interrupt. They're proposing to remove the word, and they're asking for comments. So please comment, people, before December 7th. But then they said they're going to implement it anyway. So why are we commenting? But I just want to understand that the process is ongoing.
Yeah, that's so we don't really know what it means, if it means 99% or if it means 50%. I mean, the implication is that it means always means always. It's very hard to get away from that as the implication by taking away. I mean, that's the reason they took the word normal out of the definition. So it seems to me that software engineers that could, for instance, have could learn it without a degree, and you'll see that there are 4 prongs to show specialty occupation, especially under that first prong. Depending on, and again, it's going to depend on how they implement it. But it could be tough if they require that special bachelors must be always required. But if you look, there are 3 other prongs that you could always meet, and these are a little bit easier. But for instance, if you look at number 3, if that employer always requires that that position to have a specialty bachelor's degree, for instance, I don't know, you have a big tech company that they whenever they have hundreds of software engineers, and whenever they advertise, they put a bachelor's degree in computer science, then that could be the saving grace for them. There are two other prongs that you could meet if you can show that other organizations they require such a such a specialty bachelor's, or we can show this particular position is so complicated. If you have some sort of physics position that is just is so complicated, or engineering position that is so complicated, that you could also show you would also be able to show specialty, a specialty bachelor's requirement, where otherwise there wouldn't be,
So what I'm seeing here, Cliff, is, people think, oh, well, I'll put an H1 together, and you put in a job description and attach a diploma and you file it, and everybody talks about commoditization. When I read this, what I see is that each and every H-1B has suddenly become an incredibly complicated, sophisticated application. I know I'm plugging for a firm like ours, but those guys who go out and hire lawyers who sort of think it's about filling out the form and checking the blocks, what I'm seeing here is that most H-1Bs now, to navigate the labor side of it and to navigate the DHS side of it, requires a level of sophistication which, quite frankly, we haven't seen before. And that, people call up and they're like, oh, how much do you charge for an H1? How much? They're looking for the cheapest possible price. That may actually not be very smart under this new framework. You may actually want to be asking, how good are you guys? Do you guys understand how to implement this, understand how to prove it? I'm just making a point because, people just don't get it. What we've seen in the last year or two is people have had 10 H-1B extensions, and then the 11th one, now they're suddenly getting denied. And it's like, what happened? Here's what happened. They made it more difficult. They made it more restrictive. And each and every application, oh, I've been approved 3 times. Approved 3 times means nothing. Cliff, I know you've seen this on.
I really want to reiterate your point. I think it's a fantastic point. I mean, at the end of the day, many employers have been spoiled with you put your job description, put a degree together, and you got an H-1B, and I mean, there's a lot that goes that goes into it, and even if that's what the employer sees, there's much more behind that. And I think with these new rules, it's just critical that
this is stressing me out. I haven't been getting enough sleep, and it looks like Cliff, I know you've been working seven days a week, like
6 days a week.
6 weeks. So sorry, I forgot. You are very observant, and I respect that so much. One does have to recharge. But the simple point that we're talking about here is, folks, as you all know, we currently are in the middle of the visa bulletin. Let's call it bonanza. If you're eligible to file before the end of October, a downgrade or a 485 adjustment, and you're not doing it, you are making a mistake. So do not miss this. Now, there's some possibility, sorry, I'm switching complete topics again, but I need to give this warning. There's some possibility that, the visa bulletin will be open for November. We won't know that till probably about the 20th, whether or not USCIS allows Chart B filings. I'm talking Greek, I'm sorry, that's a separate seminar. We have a webinar on that. We have webinars on pretty much all these topics. You can go into our library and find them, or you can just subscribe. After this, by the way, in case you didn't understand everything, and even I don't understand some of what Cliff's sharing, he's that smart. You have to listen to him twice sometimes to really understand what he's talking about, because we're kind of being technical on a lot of these criteria. But understanding these 4 criteria and understanding how they impact your case and how to apply it is now vital for H-1B approval. And I'm also talking about something else that the visa bulletin opened up for backlogged countries, moved forward. It's not a complete solution for persons chargeable to India and China, but it's pretty fantastic for everybody else. So, the door's open for the month of October. Run through it if you can. People are talking about, oh, I don't want to downgrade. It could be risky. It could be risky, and you have to understand the risk. But if you're eligible, you got to do it. So let's go back to our topic now. We are on the topic of H-1Bs. We are talking about the new proposed. We've covered the DOL reg. We're now focusing on the Department of United States. I'm losing my brain. Department of Homeland Security, USCIS. We all know that one. Call 1-800 USCIS. So, okay, Cliff, so let's dive in a little bit deeper. I think we actually covered this to some degree already, but perhaps you want to dive in a little bit further.
Yeah, I just want to mention very, very quickly, and just again, the proof is going to be, the proof of the pudding is in the eating. We're going to see how they all or how we're going to see how this is all implemented. I mean, if you look, the previous slide was really my, kind of summary of what it could look in the worst case scenario, and this is actually what the regulation does say. It doesn't say anything about common or most, but the taking out of normal does, does make it, just a little bit scary as to what might happen if they do take if immigration does take the most extreme petition. And then I just want to just mention one point as well, when it comes to establishing a practice of requiring a U.S. specialty bachelor's degree, it has to be related, and this is also in the new rule. It has to be related to the degree. So for instance, you cannot say that I have a software engineer and I always require them to have a mechanical engineering background. You can't raise yourself up by your own bootstraps, so to speak, to make this a specialty occupation when it's clearly not.
This is, thank you. And I'm going to say anybody who's practicing immigration law and anybody who's working in our offices has to know this stuff. They have to know this stuff. They have to understand this stuff. You're not going to pass that driving test if you don't know all the rules. And it's not about a 50-50 pass rate. This has got to be 100%. You have to understand how this works, how to put it together. And those people who do, their cases will be approved. Those people who don't, maybe you'll get lucky, but a lot of you are not going to get lucky. So don't rely on it. All right, Cliff, let's switch over to the employer-employee third-party worksite, which has been a headache for years. We've been able to resolve many of them. What do you see coming up in this arena?
Yeah.
Cliff?
So just in the interest of time, I'm just going to summarize it quickly. I mean, essentially, this is a tackling what they call the job shops. Consulting companies that the government believes are coming to the United States to staff tech firms and be the employees when they, tech firm employees without, paying them high wages, lowering the wages, and then, not giving them benefits, etc., at the expense of U.S. workers. So what immigration decided over the last few years, they're going to make it difficult in three ways. Number one is they're going to make sure that every consulting, every end user has to have a contract with the employer, and has to show specialty occupation in each contract. And that's number one. Number two is it has to cover the 3 years, the full time, and which is very hard because even if you're in a long-term contract for a year, it's very hard to show a 3-year contract. So what they would do is they would reduce the time usually to 1 year. And then the last thing they used to, and Bernie mentioned this at the beginning, is the employer-employee relationship. They want to make sure that the petitioner that is petitioning for the employee, that is the actual employer and not the end user who's the employer. And there was litigation on this, and immigration was really based on the regulations or lack of regulations, were forced to retract their these positions. And in this new rule, they resurrect all of these positions, and all of these are really put into the new rule.
I can only say let's pray that this is enjoined, because we're at 3% unemployment, and my computer may crash 6 months from now, and there'll be no one to fix it because we don't have any competent engineers, or scratch that, we don't have sufficient. Let me correct myself. We don't have sufficient competent specialized workers because quite frankly, they were playing video games instead of studying math at high school. And now they realize maybe that's important. But I'll try and keep off the politics. I've failed so far. But this is an unfair attack on critical and needed workers. And oh my gosh, we need more tech workers. They should be softening the rule. But this plays very well right now. The public, this is so complicated. Most of you don't understand what Cliff is saying. I don't understand some of what Cliff is saying. At the end of the day, the public don't understand what this is all about. And this is, in my opinion, likely to make it more difficult for people to get H-1Bs and green cards. And these are in occupations which, Cliff, medical research, computer science, But enough of that. Let's go to third-party work sites. What do we need to do, Cliff? What are the
Right.
documents we need to present?
Okay, so essentially, in the new rule, that a physical location is going to be where the work is actually done. You can't say, well, the end user is not the work location, but really the headquarters of the consulting company. It's very clear now that a person's residence, and this is very apropos for the COVID environment. The person's home work office is not considered a third-party site. And then when you have a third-party site, you're going to have to show contracts, work orders, some proof that what's going to be done at the worker end site, and and that it meets all the requirements of the regulations. And then the last very important point is that now the maximum validity of any petition, any H1 petition, and this is regardless of, might even have a 3-year contract. Even if you have a 3-year contract, a third-party worksite petition will have a maximum validity of 1 year. So you're going to have to renew your H-1B every year in this.
And how much is the filing fee for an extension, and how much is the filing fee for premium processing going to be?
Yeah, so it's 500 plus 500 plus 50. Well, it's going to be 1,500 plus 460 and plus 1,440 of the premium price, and that's the current rules.
But they're proposing to kick it up to 2,500, by the way.
Exactly. Yeah.
Congress has already, for premium processing, 2,500. So, I mean, honestly, they're bleeding the employer with this, and they're just making money out of this. And they're going to, because at the end of the day, these costs get passed on. They get passed on to the employer. So we're going to be paying a lot of money. I mean, employers have no choice. They're going to have to increase the cost.
Yeah, or even worse, they may even offshore the jobs to another country just because they don't want to pay the fees.
That kind of works, and it kind of doesn't work in some instances. I mean, really, you can offshore. I think all the offshoring that could be done has been done. So this really bothers me. But Cliff, I have so one thing I just wanted to clarify. So now that we have COVID and I'm working from home, which I am today, of course, my work site is my home, and I live in the most depressed area of LA. It's like, oh my gosh, there's like cockroaches everywhere. So does that mean because I live in a poor area, because I'm so poor, that it's a lower wage, perhaps? And you're saying it's not, right?
Well,
higher wage. I'm making a joke, but the bottom line is that if I live in a super fancy area where, it's so weird that San Francisco didn't have adequate wages and LA did in the tech area. That makes no sense to me. But my point is that work site, if the work site is actually a very high salary area, then you have to pay a higher salary when the person is on that project. Is that the case?
I mean, it's let me put it this way: if the regulations haven't kept in time in relation to software engineers, they certainly haven't. They didn't certainly contemplate remote working at all. So it's always a question of what is the work site? If the person works from home, is the work site their home, or is the work site the place where they telecommute to? And it's not very, very clear. And I'm normally conservative in this regard, and I do regard the home work site as a possible work site, the home residence as a possible work site. And if you live in a very high area where the wage is very high, then you'd have to meet that wage. Yes.
But doesn't it say that other than the beneficiary's residence? So
correct. Yeah. So I mean, it won't be considered a third work. It's considered a work site, but not a third-party work site.
Okay. So this underlining is great, but it doesn't solve my problem, right?
Yeah, I mean, basically what it means is, if somebody works from home, you don't have to worry now that this is a third-party work site. That's their home, and you're only going to get a 1-year H-1B.
But it doesn't apply. It only applies in the third-party context. It doesn't apply in the generic context.
Correct.
But they have kind of unofficially said that we don't have to put up a posting notice in the bathroom or whatever.
So DOL said that they've gone on record as saying you don't have to post in a home. It's not an expectation. Yes.
Got it. Thanks. Sorry, I kind of digress from time to time. So I briefly spoke about this employer-employee relationship, and again I spoke about the ability to hire and fire. Cliff, explain to us what it is they want.
Yeah, I mean, essentially, they want to make sure that the end user is not the employer, and that the petitioner is actually an employer. So in an end user situation, you have a consulting company usually, which is the petitioner, and they say the employer, but really what they're doing is they simply placing somebody at a particular work site, and the employer is really, in all intents and purposes, the end user, so to speak, and they want to make sure that's not the case. So there are a whole lot of criteria. I'm not going to go through all the criteria in the interest of time, but essentially they want to make sure who supervises
control, right?
Who controls. It's about control, supervision, payment, benefits, the product. Where it's just to summarize it, it's who's the person really working for in reality, not on paper. And if it's if it's the consulting company, then then the application will be approved. If it's the end user, then you've got the wrong petitioner.
The purpose of this is to make it more difficult for the third-party contractors, etc. And
exactly, it's
the way they're doing it, the employer-employee relationship point is a direct attempt to restrict third-party work sites, contractor work sites, the so-called job shops that people talk about. And I don't know why they talk about them in a negative context, because we absolutely need these technical skills, because there's just so many problems, so many developments, and getting good help in this area is critical. When the media don't understand this, the media keep messing it up, making stories about, some guy who got replaced. The reality is that, yes, if you have redundant skills, it can be a problem. You've got to keep up to date. You've got to do your reading, and you've got to be cutting edge. But in any event, the government is going to try and make it more difficult for people to come in who have the skills that we need. So that's the problem we have. Well, one of the problems is a gigantic checklist here. We're going to send out the full list to everybody who want to understand third-party worksite and the requirements for employer-employee relationship, but don't really have too much time for that. We want to kind of wrap this up. So Cliff, worksite enforcement, this is not a new topic. We've seen it before. We've been seeing, the only difference now is that previously they would just appear unannounced. Now they tend to do more telephonic in the COVID area, and electronic verification, which is kind of scary because you could send out 100 emails in one day.
Yeah, I mean, again, this is really codified, what they've been doing, especially under COVID, telephonic and electronic verifications. You could, you have to be, certainly very careful. I mean, once you have an electronic record, you do an email and you answer by email, you have to make sure that your answers are pristine. You can't take it back. I think the main point is that they could come at any time. It could be before the application, or it could be after the application. At the moment we've really been seeing them. For at least for H-1Bs, we've been seeing them after the application is approved. I think what's interesting.
It could be 2 years down the road, right?
It could be 2, yeah.
Forgot about this, and then
forgot about it. The job changed, the position changed. You have
the website changed, and the person got promoted or demoted or whatever, and you didn't file an amended petition.
Exactly.
And or your competitor decided to try and make trouble for you, and filed a complaint. Because complaints, a lot of these things are complaint driven.
A lot of things, yeah.
Or people get disgruntled with their boss. They just make it. So the point here that I'm trying to make, is that if the speed limit is 50, you're going to be driving at 50, not 51, not 52. Don't drive over the speed limit. Follow the rules, because they will be coming to check. And then it doesn't help anybody. Even if you are the person who filed the complaint, yeah, there's procedures to help you, but you end up with your own H-1B getting revoked, and ultimately maybe you'll get some temporary protection, but you'll get deported too. unless you transfer. So, you know, the foreign national has to be very careful right now when an investigation goes on, because at the end of the day, yeah, the employer may get fined, penalized, but the foreign national always seems to be the one who ends up with the raw end of the stick when the petition is revoked. And that means they've got very little time before they have to leave. So we've kind of spoken about the impact of these rules. Sorry, Cliff, I cut you off there, which was quite rude, but did you have a point there?
I just want to just mention one just very, very quick point about the third party site visits, is that they can actually now go, according to the new regulation, to the third party. And if the third party decides, you know, they don't want to cooperate with the site visit, then the petition can be denied, even based on, just maybe the third party is not interested, not their petition. It's why would they, why would they correspond with an officer, etc. So
like Bank of America or some prestigious employer,
yeah,
would then contract
hundreds of thousands of workers, and they get, why would they worry about something they don't even know about? So
they don't know how to deal with this. They're not set up. Yeah, this is awful for everybody, quite frankly. And these rules are not providing integrity, in my opinion. Some of these issues, and yes, I would support that you've got to follow the rules, but now the rules have become absurd. And when the law becomes this absurd, this ridiculous, what did Charles Dickens say about the law? The law is, no, I'm not allowed to use rude words. But the point of the matter is that the law here is failing us, because this seems to be undue protectionism, which I get. I understand how many million unemployment workers are, but since we're really talking about highly specialized fields here, we're not talking about the routine. You don't get H's approved in the routine arena. Almost all of these areas, and Cliff, I know from our office, you mentioned technology and medical. It seems like most of the cases we file are in those two arenas. And I believe, look, I'm not an economist, but there are two areas of the American economy which are firing right now. And the one is health, and the other one is technology. We only have two areas I know of that keep firing, and we're doing a direct assault on these two. I keep saying I'm not going to do politics, but of course, I'm very worried about what is the impact of these new rules, what is the impact on our great nation and our economy, and will this ultimately mean less jobs? Because when you bring in highly qualified technical people, they create new jobs for other people. Every H-1B worker ultimately creates 2 or 3 other H-1B workers. But Cliff, people probably want to hear from the guy who actually knows what's going on. So what's your view on this?
I definitely agree with that. Essentially, it's a question of very specialized people with very high skills that the companies that are all doing well, that are powering America, are relying on. And it's even one thing about new H-1Bs, but we're seeing even an attack on extensions, people that have been at these companies for 10 years, which doesn't seem right to me. But
so
I agree with you on that.
So folks, we're going to send you out this PowerPoint probably tomorrow with this recording. Hopefully you can fast forward through the bad jokes, because my humor is not my best thing. Hopefully this DHS thing is going to get if you're interested in, we're doing a lot of litigation nowadays, reach out to us, 1-800-VISA-LAW, or Bernard at Wolfstorf. Here is the contact. We haven't added the address of our new Boston office, which I'm very proud of. Because of our technology, Boston's leading firm, Chin & Curtis, has joined us. So if you're in Boston and you want good counsel, just call us on the 1-800-VISA-LAW, and I'll forward it through to our Boston office, which I'm so proud of. And thank you, Chin & Curtis, for joining us. So this is Bernie Wolfstorf. I am in the Los Angeles office. No, wait, I'm in the Santa Monica office. No, wait, I'm in both of them. No, wait, I'm actually working from home. But we do have these offices. We are a national law firm with our Salesforce-based technology. You really want to look at this technology. It is, I've heard words like jaw-dropping, state of the art, next generation. We have very advanced technology thanks to our IT director, who's a PhD in artificial intelligence. So in order to reach us, 1-800-VISA-LAW, to Cliff, who's clearly the smart one in the group. Thank you so much for your deep insight. And thank you all, everybody. I'm sorry we didn't get to questions today, but there is an address there called VISA-LAW@Wolfsdorf, and it actually comes directly to me. But if you want to get a smart lawyer, then you email C. Cliff Rosenthal. I think Cliff@Wolfsdorf works. Thank you so much, everybody. It's been an absolute pleasure speaking with you today. And I hope that you have learned a few things, because I have, listening to Cliff talk. So thank you very much. And please watch out for our next webinar, where we will share our insight and information for you today. Thank you so much.